might be able to see what the shot looks like.
It's wide. It's really wide. You'll be fine.
Okay.
So, I guess the question was, do we have anything interesting to say about the Naruto case? I don't need to do like an introduction and stuff, because I'll do that separately.
Yeah.
But what had happened was, of course, we have this joint motion to dismiss an appeal that was filed by, what, PETA?
Yeah.
Or should we say, Next Friends?
Yeah, that's cute. So we've got the monkey, Naruto.
Which is not a monkey, it's a macaque.
I apologize, macaque. I stand corrected. I want to be factually correct. Macaque. Because that's legally relevant somehow.
This is Naruto, and this is a fully public domain image as far as we know so far.
Yeah, I feel pretty confident in telling you it is.
Yeah, it could still be appealed to like the Supreme Court.
But no, it's just not.
But so far, Wikipedia has been confident.
Yeah,
in
as well they should be, because the entire argument is insane. So for those of you maybe unfamiliar with the background, the wildlife photographer went out into the wilds, and Naruto, the macaque.
He's pretty, don't get me wrong.
Actually took the shot. He was the one that actually pushed the button.
Those are some perfect teeth. I mean,
yeah.
Really? Those are some perfect teeth.
It's a good selfie.
My orthodontist would be proud.
But he is the one that literally pushed the button to release the shutter on the camera. And so we got this beautiful selfie. And then
wait, let's back up for a second though. He didn't just walk up to the camera and press the button.
That's true.
It was David Slater, the photographer, had set up the camera and had been working on training the macaque to press the button and look into the lens.
This is all true. So I mean,
this is as close to David Slater's copyright as you can get without it actually being David Slater's copyright.
Right. Because photography is considered the copyright of the person who actually took the photograph, regardless of the composition and lighting and all that stuff. So it's the person who actually took the image.
Fixes the work in a tangible medium of expression.
Exactly. That's the way
they own the copyright.
That's the way the Copyright Act reads. But it has to be a person that fixes it, and macaques are not, despite PETA's wishes, people.
Are not people, and therefore do not have standing under the Copyright Act.
No.
Because it does not expressly grant standing to animals. Now, I'm reading that from PETA's joint motion to dismiss the appeal.
Right.
Now, I say PETA's joint motion because PETA in here says that David Slater really doesn't have anything to do with this and doesn't care about this dismissal
David Slater
and just goes along with it.
Yeah, so they had reached some sort of agreement at the trial court stage where they were essentially licensing it to Slater, but they weren't releasing their copyright as part of their settlement agreement. But before they had settled, they had formally appealed to the Ninth Circuit because the trial court judge ruled that the macaque did not have standing under the Copyright Act to bring a complaint and dismissed the case at the trial court stage. So PETA appealed, and they had a briefing and all that stuff, and then reached some kind of agreement with the person that did the arrangement. And once they reached the arrangement, they said, well, there's no live controversy anymore, so we've settled, and there's no case, so we should dismiss. And 99% of the time, the court would say yes, but not so much here.
Not this time.
Not so much.
On April 13th, the clerk entered the order from the Judge Rebreno, Bia and N.R. Smith Circuit Judges and Rebreno District Judge.
Right.
The Honorable Eduardo C. Rebreno, United States District Judge for the Eastern District of Pennsylvania.
Yes, he was
by designation.
Yeah, which is weird that he was sitting by designation.
So we have a Pennsylvania judge sitting
Pennsylvania
for the
judge.
Ninth Circuit, which is what, California?
It's the West Coast. Yes, it's California, Coast. Oregon, Washington State, Alaska, and Hawaii. So yeah, we got a Pennsylvania judge. Yeah.
I didn't remember that.
It covers a huge. Yeah, it covers a huge. And Nevada. It covers a huge swath of the country. Like 20% of the country is in the Ninth Circuit. But for reasons, we've got a Pennsylvania judge sitting on the Ninth Circuit by designation.
Maybe
because
we'll have to figure that out.
Well, no, I mean it's not a big deal. I mean it happens.
It happens when there's a vacant.
Yeah, it happens not infrequently. You know, they need someone.
An empty seat.
They need someone, so the chief judge appoints someone. It can be any sitting federal judge.
Okay.
And it just so happened in this case that they picked someone from the East Coast, which is a little unusual. Usually it's someone within the circuit, but you know they were available, so okay. And so we
Judge Rebrano, I'm assuming with Judge Bia and Smith, writes that on September 11th, 2017, nearly 2 months after the court heard oral arguments in this matter, 2 months after the Ninth Circuit Court of Appeals heard oral arguments, the parties filed the joint motion to dismiss the appeal and vacate the judgment. They were basing that on a settlement where PETA was going to have David Slater give 25% of his gross revenue from this photograph. That settlement is still valid. This doesn't deny the settlement.
The settlement is absolutely valid between the parties. So there is no live controversy between the parties. But the court said, look, this basic deal is, look, we've already had briefing, we've already had oral argument, we've already begun our deliberations on this case. And more importantly, we, the court, think that you're doing this as part of a manipulation.
Well, hang on, we're going to get to that part. The judge then says the motion to dismiss the appeal and vacate the judgment, the motions are denied.
Right.
First, the permissive language of the rule, Federal Rule of Appellate Procedure 42, allows voluntary dismissals that may be dismissed. And the judge has discretion to dismiss or not dismiss. The grant of voluntary dismissal is not mandatory, sometimes is not advisable. Our sister circuits have found a number of circumstances in which it's appropriate for a court to deny requests for voluntary dismissal and vacator. We believe that rationale applies here. They go on to cite a 1983 11th Circuit case, Ford v. Strickland, an en banc opinion, which means the entire circuit sat. The 11th Circuit took a capital case, which is capital murder.
Yes.
To resolve several important issues that repeatedly arrive in capital cases. When a communication was received purporting to be a request by the defendant that all appellate proceedings cease and that the state judgment be carried out, the court denied the request and published the opinion. The court invoked the motion's untimeliness as the reason, but the request had been made after a full briefing, extended oral argument, several months of deliberation. Judges sought to resolve and reconcile the various issues. Here, as in Ford, a decision in the developing area of law on whether a macaque owns a selfie would help guide lower courts.
The answer is no, by the way.
What?
That they can't. The macaques can't get copyrights. I'm just telling you. No, the answer is no.
Well, but that's... So what do you think PETA was after, though? PETA was trying to establish animals have rights.
Yeah,
They wanted this animal to be one of the first animals to have rights.
Yeah, PETA wants the answer to be yes.
And I get it.
Yeah.
I get it. I want animals to eventually have some kind of recognition for rights or protections that are higher than their property. Do what we want.
No, I think there's a lot of rationales to extend them more than just plain property rights, because you see this in other contexts, like divorce cases being perhaps the most obvious, where it pops up, where spouses are fighting over the custody of the pets, and this becomes a real problem. And you've seen courts actually issue what are effectively visitation orders for pets as part of custody settlements in divorce cases, because people are tied to their pets and they have a relationship with their pets, and there's nothing wrong with that. So there is some
very positive.
There's some positive movement in that, but. Yeah, this copyright is, no.
Now, the court goes on to say that this is not in a singular case. So trying to establish Naruto's rights is not a one-off thing.
Right.
Cetacean Community v. Bush in 2004, Tillicum People for Ethical Treatment of Animals versus SeaWorks Parks, Citizens to End Animal Suffering Exploitation via New England Aquarium. Previous one was 2012, that one was 1993. The judge goes on, the 7th Circuit in another case, 2004, Albers v. Eli Lilly, declined to grant an appellate's motion to dismiss for reasons similar to this case. The district court dismissed a tort action against Eli Lilly on statute of limitations grounds. The plaintiff appealed. After oral argument, after a draft of the opinion had been written, the Albers moved to dismiss the appeal. Right. The reason for the motion, the court concluded, was that the law firm representing them had a substantial portfolio of similar cases and was attempting to manipulate the formation of precedent by dismissing the proceedings that may lead to an adverse decision while pursuing the winning cases to conclusion.
Right.
Invoking its authority with respect to Rule 42 to exercise discretion to curtail strategic behavior, the court denied appellant's motion and filed its already drafted opinion. The court thought it best to foil an attempt to make the stock of precedent in one area look more favorable than it really is.
Right.
Same thing that PETA is allegedly trying here. I can't speak to PETA's exact internal motivations, but it definitely seems like people who advocate for animal rights would be advocating for animal rights in this case too.
Yeah, I mean, if you invoke the authority of the court, that comes with a whole host of responsibilities. It's not just merely a relationship between the parties. It's a relationship between the public, because the public is ultimately served by the judicial branch as it's served by the other branches of government. So if you go invoke the protections of the judicial branch in the form of filing a lawsuit, well, the public has an interest in that outcome too. So normally, as I said before, in 99% of cases, it's one party versus another, and the public's interest is merely in making sure that the law is fairly applied to the facts at hand, and the parties are able to reach a resolution. Again, 99% of the time, most judges are thrilled. They would love for you to reach a resolution. Judges sometimes have been known to all but pressure parties to reach settlements under certain circumstances. So the idea of parties settling is not unusual or unexpected, and some judges do everything in their power to make sure that it happens. So that is a totally normal outcome. What's unusual in this circumstance is that the court has found that the parties are manipulating the legal process in a way that does not benefit the public. They've conjured the situation to protect themselves while creating a deficit to the public, and that's why the court seems to be intervening here.
Yeah, they say, as one of our colleagues once warned in a similar context, courts must be particularly wary of abetting strategic behavior on the part of institutional litigants whose continued interest in the development in law may transcend their immediate interest in the outcome of a particular case. For all the foregoing reasons, we believe it would be improper to grant the parties' joint motion to dismiss and vacate the judgment. Accordingly, the motions are denied, which means we're going to get an opinion in this case.
We're going to get an opinion on this case.
And I'm going to bet the opinion says no copyright.
No copyright. No, I'm happy to be a betting man on this one.
We in fact we're so confident, or rather we accidentally printed 4 copies. That we actually have 4 copies of.
We accidentally printed 4 copies of this.
And we've committed copyright infringement 4 times.
Yeah.
Or rather, not committed copyright infringement 4 times.
I'm pretty confident on this one. It was a truly absurd argument in my humble opinion for PETA to bring this complaint, and it's just. It's amazing that they were not laughed out immediately.
I don't necessarily have it on the screen in front, but I'll put it on the screen for the edited version. But there is a statement from them. When they settled it, they really took credit for it.
I remember this settlement
PETA's groundbreaking case sparked a massive international discussion about the need to extend fundamental rights to animals for their own sake, not in relation to how they can be exploited by humans. Thanks to this settlement, sales of the photographs that Naruto indisputably took will help protect and support him, his community of macaques, and their Indonesian home. The joint statement from PETA and Slater said that PETA and David Slater have agreed that the case raises important cutting-edge issues about expanding legal rights for non-human animals, a goal that they both support, and they will continue their respective work to achieve this goal. As we learn more about Naruto, his community of macaques, and all other animals, we must recognize appropriate fundamental legal rights for them as our fellow, etc., etc. To further these goals, David Slater will donate 25% of future gross revenue, that's revenue before expenses, from the monkey selfie photographs. It's not a monkey. to charitable organizations dedicated to protecting and improving the welfare.
I'm going back to Monkey because PETA, as the next friend, the legal representative, has officially.
Not a monkey.
Apparently, it is. They officially described it as a monkey.
A monkey is a species. It's a different species of animal.
Well, I don't know what to say. Tell it to PETA.
You're disrespecting the macaque's species.
I'm disrespecting many things about this case. That's true.
The judge also notes that PETA joins appellants in the motions to dismiss the appeal and vacate the district court judgment and claims to have reached a settlement with the appellees. It also points out that Naruto is not a party to the settlement agreement.
That would be hard.
So Naruto is not settling the case, just PETA and David Slater. It appears the settlement agreement would not bar another attempt to file a new action.
How are you supposed to get a settlement agreement, which essentially is a contract?
Yeah, so they signed a contract, but it didn't actually...
How is the macaque/monkey/whatever supposed to agree to a contract?
Well, I even think we put monkey selfie as a tag because people search for monkey selfie.
Yeah.
So, we're guilty of that too. But yeah, I don't even know.
Yeah, I this is a rare occasion when I get to applaud the Ninth Circuit. Yeah. They recognize something as being truly absurd, and they recognize the parties.
This is truly absurd.
Yeah, this is so absurd that it's amazing.
Don't get me wrong. Let's say what's absurd. It's not absurd that an animal should have rights. It's absurd that any lawyer would file this action thinking that our law supports an animal having copyright.
It's absurd because every lawyer is bound by ethics, one of which is not to file frivolous cases.
Rule 11.
And this is about as frivolous as it can get, in my humble opinion.
So PETA has a win here, though. They got 25% of gross revenue.
They got 25% of nothing.
Well, it's a public domain image, so really who is going to be paying for it unless they really want it to be David Slater's print of the...
If you want to give money to PETA, you just could give money to PETA and save.
You can just give money to PETA.
You just save the trouble.
So they get 25%, or at least 25% goes to something, that they wanted it to go towards. But this settlement doesn't go. This appeal doesn't go through. This dismissal of the appeal doesn't go through, and we're going to end up getting law that confirms that they can't do what they tried to do.
It's just so satisfying for me as an attorney because you do see people manipulate the system, usually not this badly, and it seems a lot of the time that they somewhat get away with it. And it is very satisfying every once in a while when a court takes the time to say, you're playing games. That's not how this works. This is not a game. This is the real world, and you can't sue someone as a game. You can't sue them as some sort of just mere coercion. You can't sue them because you just feel like it. You have to have an actual viable legal argument. Right. And when you come to court and you've got nothing, and you're playing games and you're playing with the courts don't like it, and it's very satisfying to see them say, "This is enough."
Yeah, I agree.
So I'm very much looking forward to this Ninth Circuit opinion. My only hope in my heart is that it is written in a certain, certain sarcastic,
of writing it.
entertaining
we got the
style.
Star Trek opinion out of the Ninth Circuit.
Something with a little bit of flair and a little bit of color to it.
I want to say there were one or two other colorful opinions out of the Ninth Circuit as well.
Because legal can sometimes be dry, but every once in a while you can see something with a little bit of entertainment. And
the Ninth Circuit's always fun. So is Judge Posner, who's the Fifth Circuit.
Judge Posner recently retired, so he's out now.
Well, he's only written 80 books or something.
Yeah, he's only written 80 books and 3 billion opinions. He's only the most influential circuit judge
of our
time, other than Learned Hand from back in the day.
Yep.
He's as influential as it gets.
Now it's time for somebody else to fill those shoes. Holy mackerel!
Good luck with that.
It's not going to be me.
No, I know.
I don't even if my career takes off, like I'm not Judge Posner.
He
is a remarkable person.
He was the best of the best, and he was arguably, in a lot of ways, more influential than most Supreme Court justices. Just because, for a lot of reasons.
Well, Supreme Court doesn't handle nearly as many cases.
Exactly. I mean, that's one of the primary reasons, because so many cases stop at the Court of Appeals level just from pure volume. So and
if he does a good job,
yeah, other
Supreme
circuits
Court doesn't have to
exactly. Other
overrule it.
circuits look to him. So I mean, that'd be
interesting to look up his statistics versus everybody else's.
Yeah.
How much was he overruled?
Yeah, but he was certainly one of the best, and it's he did fall off a little bit in the very end, but he was super influential in the law. I don't know if there's anyone like that. I would have said Judge Kaczynski at the Ninth Circuit, but he recently ran into trouble and he had to resign due to sexual harassment allegations.
Yeah. That'll do it.
He was a candidate for that tier, but not so much now. Wow. So yeah.
Okay, so is there anything else you want to add on Naruto, our friend, the macaque?
I just
here with the perfect teeth.
I think
it's a beautiful photograph.
I think the biggest takeaway that really is a value is probably the broader principle. Just companies and corporations sometimes use copyright and DMCA in an abusive way. They use it to take down things that are disfavorable to them. They use it to suppress opinion, and
in this case,
I think this is an example of how that can bite you, and why it should bite you. And I hope that this serves as a bit of a cautionary tale to people that the courts are not a game.
Yeah. What would have been the consequence if a macaque can suddenly own a selfie? I mean, it doesn't necessarily change everything because how many animals can really take selfies? Yeah. But you can bet that there'd be some person or group of people or whole body of a whole new genre of either videos or legal situations where people set up photographs for animals to take their own picture, and then there has to be a person who acts as like a trustee or advocate or something for that animal because the animal doesn't know what the legal system even is. It's a slippery slope of all slippery slopes. That's a real slippery slope.
Yeah, what is in the interest of the macaque in any way?
What if the macaque doesn't want it?
Yeah, that's right.
How does he even tell you if he doesn't consent?
Exactly. No, I mean, PETA had really ultimately, I think, zero interest in the outcome of this case per se. They wanted the precedent to be able to expand animal rights in a broader sense.
And
they want to say
how many donations they'd get if they were the ones who got animal rights in the courts.
If they have a right to a copyright interest, then surely
they got a ton of donations just for filing this case.
I bet you they did too. They probably wound up better off overall. But and I seriously doubt this will, ultimately hurt them. But PETA, like any organization, is more than entitled to their opinion. If they want to use the mechanisms of freedom of speech, they have my absolute blessing. They can come forward.
Yeah.
They can forward their opinions, just like you or I, in any medium that they choose.
I don't always agree with them, but they have the right to exist.
Exactly, they have the right to exist. They have the right to lobby. They have the right to raise funds. They have the right to express their opinion. It's just that the court is not the appropriate venue for that. It's not an appropriate venue for PR, and that's sort of what this was.
What would be the appropriate venue if we wanted either macaques to have copyrights or just animals to have more rights in general? It wouldn't be the courts.
No, it'd be the legislature.
Be the legislature.
Yeah, go pass some laws.
And we've seen a little bit of this. Some legislatures, well, I don't have anything prepared off the top of my head, have moved towards giving animals some additional rights. Not like civil rights, just that they're more than property and they deserve to be treated with care. That sort of thing.
No, and I think that sort of argument makes a lot of sense.
Absolutely.
There's a element of protection that's required for animals. We've seen, when they're truly abused, like in dogfighting or that sort of equivalent, we're all outraged as well.
And you
can
see the damage. You can see the emotional trauma that even a dog suffers.
And they're worthy of some sort of basic protection beyond just property. They're not a cell phone that I can, just throw on the ground and dispose of. It doesn't have any feelings, doesn't care. But, my cell phone I can go beat with a hammer, and it doesn't care, and neither does the law. But
animals do.
But animals do, and there's an argument to be made. But this, the law was not meant to protect the copyright here. They were abusing the law to achieve a political end that is not appropriate in the courts, and it was the wrong venue, and they got bench slapped, as they like to say.
Bench slapped. There you go.
And they deserved it.
Bench slapped. That might be the title of this.
Okay.
Might be the thumbnail title of this.
Fair enough.
Is PETA gets bench slapped.